So, counsel, I want to echo what Justice Gorsuch said. I mean, it seems like there was some real unfairness to your client. I mean, frankly, reading the briefs, it sounds to me like this tax assessor was like Inspector Javert, but it was even worse because Jean Valjean hadn't stolen the bread. I mean, you didn't even owe the tax, and it's this small tax and the big, the big loss of the family home and of the money. So it does seem that there's some unfairness there. But I'm struggling to see how it fits into the takings framework. Can you tell me of a case that we have that treats the foreclosure of a house as a taking? I mean, Tyler treats the pocketing of the surplus as a taking, but I'm not aware of a case. I just don't know if it fits this framework. I'm not aware of a case of ours that says that when the government forecloses on the house, as opposed to when it pockets the money, it's taken the house.
The best I can point this court to is Tyler, and I think Tyler was specifically written with the words about value as opposed to surplus proceeds if we look at many of the passages in Tyler itself. What's important, I think, is that historically, under the common law, under debt collection schemes that are developed by states, there's always a back-end protection on the former property owner. There's a sales confirmation. There's a review process. There's a channel.
But none of that answers whether it's a taking. Okay, well, let me ask you this question. You say that it should be fair market value. You also say the taking happens when the government forecloses on the property as opposed to when it sells the property at auction?
In this circumstance, yes.
Which is the right date for gauging the fair market value if there's a gap of a year?
When they take title. When they assume full and complete title, that is the taking because the person is dispossessed of the ownership of that property at that point.
So the property falls in value, and that's the government's risk.
It is, but it's also the government's benefit if it goes up in value, as Justice Gorsuch points out as well. It's the time. This court has always said we measure precisely at the time of the take is what the value of that property is.
Okay, so let's say I don't think Tyler settles the question whether the foreclosure is a taking. Then I think Tyler leaves open and might treat just the pocketing of the surplus as the taking. Why couldn't I view the foreclosure of the house as just an exercise of the taxing power and not a taking?
Because the government is taking more property than necessary to fulfill the debt. Because at that point, they're no longer a debt collector anymore. When they've taken that much property over the debt itself, they've become a confiscatory government now as opposed to a debt collector. If a client doesn't pay my bill, I don't get to go seize their whole entire house. I can only collect on the piece of the debt that I'm entitled to do so. Government has different powers. They can act as a super debt collector, and they're utilizing their takings power to be able to take more property than necessary. And when you trigger that taking obligation, here, again, what's taken is not the surplus, it's the equity that's in the home at the time of the taking. That's what triggers the obligation to pay just compensation because the Fifth Amendment requires it.